Okay, good afternoon. Thank you for joining this webinar that may provide some merger and acquisition solutions to family law and shareholder or LLC member litigation. I'm Tom Pastore. Could we go to the next slide, please? All right, so 4 topics we're going to cover today are the risks of continuing litigation in family law and shareholder dispute matters, the possible win-win resolution to all parties of selling a company, and what situations are candidates to sell the companies on a great side and also on a good side too. And then which transaction support services are necessary from various professionals like a business appraiser, but CPAs, transactional attorneys, insurance people involved in M&A, and other consultants. So I'll give you a quick overview of our firm and the experience we've gained after this. But if you please stay until the end of this presentation, we'll have a live Q&A and the opportunity for you to schedule a 15-minute consultation in the next few weeks with me. You may at any time in the chat submit questions, and I'll also take them live. All right, so our 2 founders are to the left. We're in our little waiting room. That's Nevin Sanli. Most of you know him, and that's me. And then we have a managing director in Sacramento, a business development person, Jim Green, in San Diego, and we have 2 managing directors, one in Europe and one in Africa. All right, next slide. That's me. The thing I'd only say is towards the end of this, I and both my partners, Forrest Vickery and Nevin Sanli, have testified in 70 trials and over 200 depositions. But in addition to that, that's about 1/3 of our total work for each of us. The other third's in merger and acquisition valuations and fairness opinions, and the other third's in compliance valuations, matters such as state tax and financial reporting, where M&A or merger and acquisition due diligence is done. Okay, next slide. So let's discuss litigation risks. Probably know it's very expensive in California, and it varies case by case, but the costs include substantial attorney's fees, expert witness fees, court filing fees, among others. California is known for being highly litigious in civil litigation, and court cases can drag on for some time and become quite expensive. So typically, experts in valuation and forensic accounting will be testifying in California in family law matters, shareholder disputes, LLC member disputes, intellectual property, and real estate. And litigation is, full of surprises. The opposing party can just be downright contentious, mean, emotional, rather than pragmatic. In family law matters, we call it divorceitis. We have that nickname in the forensic world, where people just all of a sudden act very differently than they used to and take actions that perhaps don't make sense from an economic perspective, except selfishly, perhaps for them, as opposed to the other parties. And as people in the audience that work in litigation know, judges' rulings can significantly extend lawsuit duration, which runs up the fees of lawyers and expert witness fees. And it's not uncommon in some shareholder dispute matters and family law matters for the judge at the end of a day in a trial of several days to all of a sudden have that calendar filled up and push out your client's case several months. Naturally, that's going to result in increased fees for your clients because in several months or a year, there's restartup costs that the attorneys and the expert witness have to do to refamiliarize themselves with the case. And, awards may not be honored. Litigants can file bankruptcy. And in several cases that I know, they can flee the country. I'll show you an example in the next slide of an unsuccessful attempt to flee the country. That did not work out. Okay, next slide. Now, there may be an alternative win-win opportunity to sell the company. It may not happen in many or the majority of litigation cases, but there are circumstances that I will go into that can provide a path to resolution that's much more efficient and overall benefits all the parties. Because if you can sell the company, especially early in the litigation, it cuts off that litigation cash drain and mitigates the legal uncertainties and the lawsuit duration. Because you just don't know sometimes, or a lot of times, how a judge is going to rule on certain things. Okay, and of course, a sale of a company will provide near-term cash proceeds to all parties. So in family law matters, to both couples or all shareholders or LLC members. Okay, we can go to the next. Okay, so what situations work for win-win? And really these items, as I thought about it more, this is what situations work very well for win-win, because there's other situations that'll work too. But let me go into the ones that really provide strong support for considering very strongly in selling the company to mitigate the unknown effects of litigation. First, a business's history of profitable operations gives the potential buyers comfort in the stability of the company and its ability to do the same into the future. A diverse customer base with recurring revenues from these customers is a very strong selling point for the company. Because if you don't have, or if you have a concentration of a few customers or one customer, there's a risk that the company's financial operations will be seriously detrimentally impacted if you lose that customer or those few customers. Strong systems and procedures is another great infrastructure to have within a company. And these days, IT systems and HR systems are very important, especially in California. And then we'll go into intellectual property in the next slide. And then a well-trained, long-tenure employee base gives a buyer comfort that they have the human resource infrastructure to be successful into the future. And improving or strong industry and or merger and acquisition market conditions also present a very good opportunity to sell the company. Okay, now let me give you some exceptions to this for situations that still work well for a win-win. So a business history of profitable operations is usually because a company's in a mature industry. But if you have a growing startup company, let's say in the burgeoning industries of clean tech or something related in, let's say, supplement, nutraceutical, or healthcare applications, and if they're well capitalized and appear to be on the growth path, you don't need a history of several years operations, because there'll be buyers out there, larger companies or private equity companies that find these new industries attractive. And there's certain fintech applications, fintech industry participants that are found attractive, but not cryptocurrency. Now, a diverse customer base is always preferred, but if the company has very good long-term relationships with a handful of customers and it gets recurring revenue, that can be a strong selling point, particularly if they're government customers that the company's had a relationship for several years with. And I'll get into an example right at the end of this seminar that shows that. All right, let's see. Okay, next slide. So company size considerations. For lower, mid, and higher end middle market companies, there may be differences in factors creating a business's value proposition. So just to put some perspective to those descriptions, lower middle markets, in my experience, typically 50 to 30 or $50 million in annual sales. Mid markets above 50 to about 150 million in annual sales, and higher end is 150 up to 5 billion. Some people say 2 billion, 2 billion to 5 billion. It can often be the start of like the unicorn status of a company that is grooming to go public. So In terms of the higher end, mid and higher end companies, they usually have broader executive management ranks, reducing key person risk. So that is something that is very attractive to buyers of companies in that space, because they'll have enough executives that the loss of one or two of those executives won't impact company operations. Whereas lower middle market companies typically have a lot of key person risk in the CEO. And that can be substantial and a negative impact to the company if the CEO can no longer work at the company. So also the mid and higher end companies operate nationally and internationally. So they usually have less or highly reduced customer concentration exposure. On the other hand, the benefit of a lower middle market company is that it may be an industry that is highly that is rolling up. In other words, the larger companies are buying up the smaller companies, and they do that and offer a premium price based on the expectation that they'll reduce the redundant cost within the seller's organization, within that smaller company's organization. Now, some unique intellectual property assets that have strong protection attract buyers too. And typically they fall in 4 categories. There's others, but the main categories are trade secrets, patents, trademarks, and copyrights. So basically, trade secrets are processes, technologies that a company has that it doesn't reveal to the public. Whereas patents are strongly protected intellectual property on technology usually, but they also have to publicly disclose how the technology works. And therefore, a competitor might be able to reverse engineer enough of the technology and still safely sell a competing product because they haven't completely reverse engineered the technology. Trademarks are the brand names, and copyrights are usually associated more with music catalogs and literary works. The benefits of these type of IP are twofold. First, it's directly to business operations of the company by enhancing revenues or reducing costs. And then indirectly, the company may have strong enough intellectual property that they can license out aspects of it, such as medical technologies and whatnot, and receive licensing fees for another company's use of a licensor's technology. But it's essential in either case that the business has a strong legal team of IP attorneys and access approval procedures for employees and other users in the organization to protect the assets. Okay, so now we'll move on to the next slide, and we'll discuss how, if the M&A solution is possible for your client in the matter, how that can be used, okay? So the one thing I wanted to talk about first is, though, that compared to other aspects of civil litigation, where there's economic damages involved, but there's, there's a question of whether the plaintiff can prove liability of the defendant. The family law matters in community property states like California, and the shareholder or LLC member matters have an end in sight, because in divorce and community property states, you're going to divide up the assets based on their value. That's the resolution from an economic standpoint. In shareholder disputes, you're going to buy out the shareholder at fair value or fair market value. So that's why there are M&A alternatives that are possible for suitable companies. So this is basically the overall menu of transaction support services that are offered by financial advisors and valuation people like myself and people at my firm, but also it's a team process. So you involve investment bankers, CPAs that are familiar with M&A, insurance consultants or insurance brokers that deal with board of directors insurance and other coverage for representations and warranties in a merger. And other consultants may be brought in on a case-by-case basis. And the transaction support services can be customized to each particular circumstance. So this menu may involve all of these dozen points. It could involve one or two. And I can give an example on both ends. If we have what we call a long tail transaction support service, we may be, as an example, retained prior to any potential reaching out to buyers or marketing the company for an acquisition. So we may be asked to do valuation analyses, and then the client might say, yeah, I do like where that value is going. Let's start a team and let's hire investment bankers, deal attorneys, and M&A CPAs. And then the investment bankers will start the pitch books to be distributed out to whomever an interested buyer is. And we can review the pitch books and help with that. Then once buyers come in and start making offers, we'll analyze those offers and present counter offers. And then we'll negotiate the deal. There'll be offers, counter offers, due diligence will be performed, and then we'll find the buyer, whoever our client selects. We'll analyze the purchase and sale agreement, and then we'll close the transaction, make sure the inventory, let's say it's a manufacturer, the inventory is at a proper value and the accounts receivable too, because those are paid for on the day the transaction closes. Since it's working capital and it varies on a daily basis, you have to wait till the close of day. So that's a long tail transaction. There are other circumstances where us and the other transaction support service team members are retained for a short-term basis. So the deal may be consummated, almost consummated, and there's a purchase and sale agreement draft, and they're ready to pen and ink it, but the client may want us to review the purchase and sale agreement to make sure all the terms that are understood and agreed to by the parties are contained in there. And then we will assist in closing working capital adjustments. So we might just get 2 out of these 12. So, okay, next slide. I want to concentrate now on the various types of transaction support services that we get involved with, and other advisors on the team get involved in on a more frequent basis. So in corporate partnership and marital dissolution, stakes are often higher. I mean, the owner's probably been in intensive litigation. It's very emotional. And so it's very important to get the right fit M&A and other attorneys, the business appraisers, CPAs, insurance professionals, and other consultants. And what we typically do is we assist in finding those professionals that I mentioned here in the top box based on several factors that we do cuts on. So size of the business, we want to get the professionals that work in the space of either low, middle, or higher end middle market companies. And then industry fit too, that they have experience in the industry of the company that's going to be sold. And finally, it's often very important personality-wise with the sellers. You want to find that right fit too. Now, another very important aspect that the transaction support team will get involved in is analyzing offers and counter offers. So as negotiations move on, of course, there will be counter offers made. And so it's very important to quickly reply to the counter offer. So the transaction support team will look at the counter offer and analyze it and see how we will respond. In doing this quickly, but with full analysis and due diligence, shows the potential purchaser that the owners and the transaction support team are very serious about this transaction that's going to occur, and that they're deeply involved in this. And so this kind of loosens up the ice, and it continues the communication dialogue between potential purchaser and seller. Okay, then of course due diligence is paramount to a successful close in an M&A transaction, and it requires complete investigation and examination of all details related to the deal structure. And it's important at the start of the transaction support service process involving due diligence that the team members accurately prepare the parameters of the due diligence as they are relevant to the case at hand. So there's usually 3 to 5 points that are major points in the due diligence and what buyers and sellers will be looking at. In some cases, it could be that there is a certain amount of customer concentration, and you want to ferret out the relationship with those larger customers, the history with those larger customers, the current communication between the customers and the company and the relationship. And there can be other issues of whether IP, intellectual property, are patents going to expire, and what is the company going to do to counter that? Are they going to promote more of their brand because the industry is more from technology to more branding? That can be an example. The other thing too is it's really important that it is agreed upon in which due diligence aspects will be done by which TSS team members, transaction support service team members. Okay, next slide. Okay, very vital part of the transaction support services as a deal is going through its life, is analyzing accounting and inventory issues. And that is not just looking at several years financial statements and kind of projecting out a pro forma statement. It's a much deeper dig when you're selling a company. And it's very important that buyers, have confidence in the accounting system. If not, that's a deal breaker, basically. So what the transaction support services team should do is, of course, get several years of historical financial statements, including audited financial statements, if there are some, or if there are financial statements in the CPA, even if they're not audited, has notes. We should get all the notes. And then we have to look at the underlying accounting support, such as the underlying general ledgers, the accounting software, and any supporting documents. And so that's a deep dive into the historical accounting system and financial statements and accounting records of the company. But from that, very often, and this applies more particularly to mid to higher middle market companies, but it's done also with lower tier middle market companies, is a quality of earnings examination. So Q of E is the industry jargon. And that really helps the transaction success odds, because what the quality of earnings analysis does is it does look at those several years of financial statements, but it also involves interviewing management and look at industry data to understand how the revenues, gross margins, cash flow, and adjusted EBITDA, that's like cash flow, it's earnings before interest, taxes, depreciation, and amortization, how those should be used in assessing the going forward profitability of the business and what the buyer would pay for a, quote, normalized earnings of the business, right? So that is not often revealed just in the financial statements, because there can be fluctuations between years. There can be excess perquisite non-business expenses. Margins can fluctuate because you might have a commodity type business with commodity inventory. And you have to look at fluctuating inventory and accounts receivable working capital. So what is important too is what is called a Q of E ratio. And that's the numerator, the ratio of operating cash flow divided by operating net income based on generally accepted accounting principles and accruing principles. So you want a Q of E ratio of 1 or above, because it shows that the cash flow matches or is superior to the accounting income. And it's all about cash flow with buyers. So a ratio below 1 starts to indicate that reported net income doesn't come as close to real economic cash flow. And so as it gets below 1, then there's deeper dives that have to be done in due diligence in the quality of earnings examination to basically unearth the representative cash flow or EBITDA that a valuation multiple is going to be applied to. And then finally, for manufacturers, wholesalers, and retailers, analysis of inventory is very important to the deal structure. So if the analysis of accounting methodology shows that, let's say, inventory accounting has been consistently last in, first out since inception of the company, that gives you a lot of good confidence, or a buyer, importantly, a lot of good confidence in the accounting for inventory. However, if that is not the case, if inventory methods are changed frequently, and as a result, each time there's a change, it improves the gross profit margin of the company from an accounting standpoint, that raises questions in the buyers on the confidence in the accounting system and how realistic it's portraying net income versus operating cash flow. Okay. The other thing is we will perform, or the accountants typically will perform, or consultants also will perform, an aging and obsolescence examination of the inventory to see if there's any significant inventory that's not selling, taking up warehouse space, and probably should be, auctioned off. Okay, next slide. All right, I think the first one's, pretty obvious, but what's important is you assist in vetting a team to ensure the transaction is structured in the best interest of the client. And so, selecting the team at the outset or making replacements if necessary during the process is very important. And all right, so then the next step is an analysis of the purchase and sale agreement terms. So it is important that each of the team members, because they have different aspects by which they can look at the purchase and sale agreement, they look at the purchase and sale agreement. And so they ensure, through this process, all of us that are involved, we ensure that all understood and agreed upon deal terms are accurately reflected in this document. It's the most important contract in the whole process of a merger and acquisition transaction. And then something that we really prefer to do on the financial advisory business valuation end, as a member of the part of the transaction support services team, is to perform financial sensitivity analyses to anticipate various changes resulting from offers and counter offer scenarios. So basically, a sensitivity analysis is doing 3 sets of projections. So there'll be most likely projected sales, expenses, profit, and cash flow going into the next several years in the future. Then there'll be low side scenarios, so a lower set of revenues and profits and cash flow, and then a high side projections. And what we can do is we can make a grid that applies the various, a range of valuation multiples, let's say EBIT multiples, to these projected low, middle, and high scenario EBITDA, or cash flow. And this anticipates how deal terms may change, and assessing a counteroffer. Is there some point where it goes too low and it's not in the interest of the seller to sell the company to that particular potential purchaser? And of course, if it goes on the high side, that makes the deal all the more attractive. So it's good to have this, what we call a sensitivity analysis decision-making grid to look at in assessing counter offers as they come through. Okay, so let's see, next slide. So I want to present a case study about a successful M&A solution to a family law matter. So next slide, please. So we were hired in a family law matter. The court actually had appointed an independent forensic accountant appraiser, but the wife decided to hire our firm. All right. And the husband's business was a very successful manufacturing company with a nationwide footprint of very good customers. And so the forensic accountant, and he's a colleague, respect him a lot. He developed the value for the business using traditional earnings measures and rates of return that family law courts in most of California counties prefer. So usually they take an average of the last several years of earnings, family law cases, and then divide it by a rate of return, a discount rate or a capitalization rate to get value. And it is often the case that judges in various counties frown upon the use of a market-based valuation method, based on merger and acquisition methods, and particularly those that are weighted more heavily on the use of recent years' earnings rather than a straight average. Okay, that's the way the family law courts work in a large number of cases. But we go to the next slide. As I dug more in and did analysis, I uncovered several key factors that warranted strong consideration of the market multiple valuation method. And these factors included the business's long history of profitable nationwide operations, and then a strong customer base of large institutions. And let me explain that. Basically, this business did two things. So with government entities and municipalities, they did the utility maintenance and infrastructure upgrade. So that's recurring work all the time with the same few cities or the same cities that they had. Secondly, they also did the heating and air conditioning maintenance and upgrades for museums throughout the United States. And what happened is over time, and particularly the last 3 years, when I got on board this assignment, there was improving customer diversification, significantly reducing concentration rate risks, because this business had such a good reputation that it was getting referrals of new clients from its existing clients. And then there was unique intellectual property assets. Basically, it was the business's trade secrets. They didn't have any patents, but they had carefully guarded work processes developed over 2 decades that made them, this business, one of the most efficient providers of their services to government agencies and libraries. They could get their work done more quickly than other competitors, and that saved them cost, and they charged a premium price for that. So they had superior profit margins than all their competitors. And there were improving industry conditions at the time. So this all coalesced to say this is a very good candidate for a sale. So I did do the traditional, court, like not court favored methods, same as the forensic, which I was prepared to present, but I had the alternative market method, and I included all the factors that I talk about above in my report. I included the comparable companies that were the same size as the business, had several of the same characteristics, lower profit margins overall, and the valuation multiples based on EBITDA, earnings before interest, taxes, depreciation, and amortization, that these businesses were sold at. All right, so we exchanged the report, the forensic accountant on the other side of myself, and then I was expecting to go in to testify, but all of a sudden the judge called the parties over. They were talking and whatnot for a little while. So husband, wife, and the judge, and they came out, and then the judge said, all right, look, appreciate you valuation people coming here today, but I think we don't need to get into that. I think what we're going to do is explore the sale of the business, and I'm going to give the parties time to talk with each other. And so then 2 hours later, the parties stipulated to a settlement agreement to sell the business. And so, the judge had read both our reports. My respected colleague and I said, great work, guys, but we want to sell the business. I got a lot out of both your valuation reports, particularly the one that discussed all these compelling factors of why this is a good candidate to sell the business. And subsequently, luckily for my company, we were hired to do the transaction support services. All right, so I think what's next on the agenda? Let's see here. Well, first of all, we'll be accepting questions now. Before I go live and unmute everybody, I just have to give my most warm-heartedly thanks to Ms. Teresa Weber and Ms. Jackie Jones, part of the SPH. They are the SPH team that made this successful. Without them, I could not be doing this presentation today. Thank you, Teresa and Jackie. Okay, let's see. Do we have any questions in chat? Don't see any. Do you have any questions from the audience? All right, we are going to make the presentation available to anybody that requests them. And please request of Teresa any 15-minute consultation you want. Oh, I have the Q&A open here. That's a good question. Questions come here that does the judge have to approve the ultimate sale? I think the court has to affirm it recognizes the ultimate sale. In this case, the judge actually said that he would get involved if the investment bank was not doing a good enough job soliciting potential buyers and moving the process along, that he would move to have the selection of another investment banker made. I think ultimately, and this is really a good question for the attorneys, I think the judge has to approve both parties, that they acknowledge both parties have accepted the fact that they are selling the company at a price that they both agree to. All right. Thank you very, very much, everybody. Have a great rest of your day. And thank you for attending. I hope this was useful to you. Bye-bye.